Welcome to Want to Franchise Your Business? Intro to State and Federal Franchise Laws.
Hello and welcome to Franchising Your Business, Intro to State and Federal Franchise Laws with attorney Tim Pickwell. Tim has had a private law practice representing national and international restaurant, retail, distribution, and fitness studio franchise clients with an emphasis on franchise registration, disclosure, and relationship issues. I am your host, Kevin Rosenquist, and today's episode is Franchise Disclosure, the legal foundation of your franchise. Tim, welcome back.
Thank you very much.
So can you start by just sort of explaining what a franchise disclosure document is and why it's important?
As we just explained before, if you meet the legal definition of a franchise, to sell franchises in the United States, unless an exception applies, and that's pretty rare, so we'll ignore that for now, you need a franchise disclosure document in all 50 states. The Federal Trade Commission franchise rule requires that you use this document. It contains what we call in the trade items. It contains 23 items. Item 1 is about the franchisor, the entity. Item 2 is about the executive. So every franchisor, as we call it, follows the same format. Item 3 is litigation. A lot of information in there you may not want to disclose, personal bankruptcies, things like that, but all required. It also includes this FDD sample of every contract that the franchisee might ever be expected to sign. So you've got the franchise agreement, any exhibits, subleases, if the franchisor deals in real estate. It has audited financials. It has addendum that various states require. And as you get bigger, you have a list of your franchisees. And then you have a list of what I call the non-sales, the anti-sales list. You have to list all the franchisees who were terminated or closed in the last year so that a prospective franchisee who receives this FDD can look them up. So the FDD is pretty comprehensive, discloses that the goal is to disclose everything that a prospective franchisee might want to know about the business opportunity.
All right, now give us a little history lesson here. How has the disclosure process evolved over the years, and kind of what led to the introduction of these franchise disclosure laws in the first place?
Yeah, I have a colleague who claims that franchising started with the Egyptians and the pyramids. I can't really follow his logic, but it definitely started in the United States with.
I mean, it could have, but how much do we really know?
With A&W root beer in the 1920s and with Howard Johnson's hotels in 1930s. And then after World War II, the United States Patent and Trademark Office loosened some of the rules around licensing your trademark. And so franchising really started to take off. And then the boom times were the 50s and 60s, and you had all sorts of concepts exploding. In fact, I give clients some homework. I say, go watch The Founder with Michael J. Keaton. It's about Ray Kroc, and it's a pretty accurate depiction of that kind of heyday of franchising. So you had you had the Colonel, KFC, selling franchises. You had Carl Jr. selling franchises. Anyway, a lot of concepts growing in the 50s and 60s, what we call the boom times. But there were a lot of failures. There were a lot of celebrities lending their names to concepts, like Minnie Pearl, whose concept sold 1,000 franchises, opened just a couple of dozen, went public, and then went bust. Joe Namath, the Jets quarterback, lent his name to a concept called Joe Willie's, and it sold quite a few franchises, opened one, and went bankrupt.
Wow.
So it started to become this perception that fast-talking franchise salesmen were coming into a town and taking mom and pop's hard-earned money and then disappearing or going out of business. There are also stories of people offering terms along one line and then changing the terms when it's time to sign the franchise agreement. So by 1970, the U.S. Senate was investigating franchising. The Attorney General for New York was investigating franchising. And the Attorney General for the state of California said that next to land subdivisions, the single greatest source of complaints that his office received was from franchisees. So everyone was investigating franchising, and California, not surprisingly, was the first to come up with a franchise law, signed by then Governor Ronald Reagan in 1971. And California's solution was that you must disclose everything to a prospective franchisee. And at the time, this was called a Uniform Franchise Offering Circular, but it was a disclosure requirement. That was one part. The second part was that the franchisor must register, file some forms, pay a registration fee, and their franchise offering circular would be reviewed by an attorney in the state, and that time the Department of Corporations. And then finally, there was a relationship law that said, regardless of what the franchise agreement says, you can't terminate the franchisee without good cause and without notice and an opportunity to cure. So California passed that first law, And then throughout the 70s, another 13 states passed these registration laws, and they're kind of all over the map: Washington, Hawaii, Virginia, Maryland, New York. We get to about 1979, and the Federal Trade Commission had been looking at franchising for several years. And finally, in 1979, they issued their comprehensive franchise rule, and it required the use of a franchise offering circular. But for better or worse, they said, we don't want to preempt any existing state franchise laws. So we have to comply with all the laws at the same time. So you have to comply with the federal law, and you have to comply with the state law in California if you're in one of these registration states: New York, Illinois, California. That's a challenge. But the good news that came out of that was that all these 14 states, their laws were slightly different. Mm-hmm. And what was required in Virginia was illegal in New York. And you had to have a dozen different documents to register in these states if you wanted to go nationwide. But all these state examiners, they belong to something called the North American Securities Administrators Association. They all got together and agreed that you could use the FTC's version of the franchise offering circular. So the way to think about why we have these laws is that there was a perception that unsophisticated mom and pops were losing their life savings, and fast-talking franchisors were changing terms on them. So the terms you put in that franchise offering circular, now the franchise disclosure document, you better live with for the rest of the franchise agreement. And what you register, you better live with for the rest of that franchise agreement. But that is the basis for all the laws in the United States. And in 2007, the Federal Trade Commission massively revised their franchise rule. And so that Uniform Franchise Offering Circular changed its name to the Franchise Disclosure Document, or FDD. And that is what I've so carefully done with my life, that we draft these for a living.
How did that FDD or the franchise rule change the way franchisors need to disclose information to potential franchisees? Because you talked about how it protects the franchisors from the fast talking people, but what about the franchisees? Does that add protections for them too?
That is the goal, is to protect those franchisees. Even sometimes you have very sophisticated, experienced business people buying a franchise, but sometimes you do have these unsophisticated mom and pops. And so Sure. This franchise disclosure document, it tells them what the initial fee is going to be, or what discounts might apply if they're a military veteran. It has several important charts. So as I mentioned before, there's 23 items. And I asked an examiner in California, how she felt about some of them. And in her view, all are material. So all matter. But in my experience, there's a couple that are more important than others. And these include charts that tell a franchisee every potential fee they might ever be charged. That's item 6. And there's another chart, very important. It's called the estimated initial investment. That's item 7. And it provides all potential expenses, often in a range of what it might cost to invest in this franchise. It includes the build-out costs for a retail franchise, salaries, wages for first 3 to 6 months, insurance, lease costs, you name it. So a franchisee gets that document, and they can see the estimated range of investment is $250,000 to $350,000, or $1.5 million to $2.5 million for a big restaurant. So very important chart. And there's information about each of the executives and even their personal bankruptcies. And we had to disclose a bankruptcy of one client, and kind of called me and hemmed and hawed and said, I don't think this helps us. I said, it's not to help you. It's to help the prospective franchisee.
Yeah.
Another client, its CEO and its CFO both had to disclose personal bankruptcies, and they sold 50, 60 franchises a year. Nobody cared. So you just have to disclose litigation the company's been involved with, especially if it involves franchisees. A lot of negative information you have to put in there, but you also put in, what the training requirements are, and that the franchisee has to, pay their own expenses when they come to training. The goal is to eliminate surprises. So if a franchisee does their due diligence, reviews this document, often hires an attorney, helps them understand it, there should be no surprises. And that's a good thing. I tell the franchisor clients, that's a good thing. You don't want a franchisee with unrealistic expectations. You don't want a franchisee that doesn't understand what they're getting into. You don't want a franchisee who thinks they can, just walk away after, 6 months or a year. So the disclosure document we feel can help you sell a franchise, and you list all the costs but that is not what it's for. Its goal is to protect prospective franchisees. And when you talk to the examiners in states like California, Maryland, Virginia, that is very much their attitude. They're not there working for the franchisor.
Mm-hmm. And there's something called the North American Securities Administrators Association. What role do they play in shaping franchise disclosure laws over time?
Yeah, quite a big role lately. So I mentioned that the Federal Trade Commission revised the franchise rules in 2007, and they've basically been pretty quiet since then. Haven't done much of anything. Issued some opinions a few months ago, but other than that, very quiet. NASAA, on the other hand, which comprises these 14 registration states and others, has tweaked the franchise disclosure document almost annually for several years. They add what they call risk factors. So when you get a franchise disclosure document, this 150, 200, 240 page beast of a document, the front page is the same for every franchisor, has their logo, an estimated initial investment, how much is paid to the franchisor. And then as you go in a few pages, there's this parade of horribles that might happen if you buy this franchise. And that's what NASAA is required. They're called risk factors, but they tell you you'll have to sign a personal guarantee if that's the case, that you may be required to arbitrate out of state if that is one of the provisions. So NASA required that. Another thing they did is a little bit of inside baseball, but franchising had a lot of its own terminology and it was not uniform. So two chains might have a very similar distribution or franchise model, but one would call it sub-franchising, another might call it master franchising. And there were other relationships. Well, NASA came out a few years ago and described the 3 or 4 main type of franchise arrangements and gave them their approved name, and they've tried to standardize all the naming and franchising. So they're coming up with tweaks every year, and requiring little changes, moving this item to that section or what have you. So they've been very active lately, and I don't think they're slowing down.
Let's go back to the FDD, the franchise disclosure document. Can you talk about some of the key sections that have remained consistent over time?
Everything changed a bit in 2007 when the FTC revised the rule, but the items are essentially all the same. But I've found over time that a couple are more important than others because this is what franchisees get upset about if they feel the disclosure wasn't accurate. And these are item 7, the estimated initial investment, and item 19, the financial performance representation. So item 7 is this chart, and franchisees kind of rely on it, and it may help them get a business loan. And when their build out ends up taking too long and is too expensive, they complain, sometimes to the point of arbitration or litigation. And then I've seen situations where the franchisee did not follow the franchisor's specifications and went with higher end paneling and this and that, and ended up well over budget. And even the franchisee knew it was their own fault because they had not followed the franchisor's specifications and guidelines. But that's a really important item because it's really the first tough part of the relationship, building the franchise unit, if there is a unit. And when the budget's off, nobody's happy. The other is called, it used to be called an earnings claim, but it's now called a financial performance representation, item 19. And it can take many forms. It is the item where the franchisor gives a financial performance representation, either what gross sales are for units in its system. Some clients have even provided a detailed P&L, like a typical P&L. So a franchisee can say, if I'm going to make this is what the bottom line is going to look like. That's a little tricky. That client had been operating for a lot of years and had a lot of detailed information from its franchisees. And you can have everything in between, just gross sales, or just when you get large enough, the examiners want to see the franchisee sales, not the franchisor sales. But you can imagine when the franchisee doesn't make the profits they thought they saw in item 19, they're not happy. And often, when you dig deep, they didn't follow the marketing plan. They weren't attending to the business, but, it's rarely their fault. So I found item 7, that estimated initial investment, and item 19 to be very important. And we're just working on one for a client. They're going to do their first financial performance representation. And we dug deep, and we even found they had a closed unit, and we're disclosing that they had a closed unit. So we want all that information to be in there so the franchisee is not surprised and isn't going to come back later and say, I didn't know that. So just detailed disclosure and accurate disclosure is critical.
We're towards the end of our second episode here, and I'm just learning about all this stuff as I talk to you, and it seems very complicated, just a lot of stuff involved. Do people try to do this on their own without an attorney?
Once I found someone who did, and I wouldn't even look at their document.
Their probably wasn't very good.
No, I have a neighbor who's kind of do-it-yourselfer, and when he sold his house, they had a lot of problems because I just don't do it yourself. It's very complicated, and like similar to if you do the inadvertent or accidental franchise, you're going to find out at the worst possible moment when you're in a dispute that you pooched everything up. Yeah, I think it's just one of those things. You mentioned selling the house. My wife's a realtor, and it's like I see what she goes through and what she does. It's better to hire someone, and I'd say in this situation, trust the expert. Yes. Yes.
All right. Well, thanks for tuning in to Franchising Your Business, Intro to State and Federal Franchise Laws with attorney Tim Pickwell. To connect with Tim, visit pickwelllaw.com. And please be sure to like and subscribe our channel. Leave us a review if you get a chance. Thanks, Tim. Really enjoyed having you here. Appreciate your time.
Thank you, Kevin.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.